Hi, everyone. Welcome to the Billy Wilder Theater. I'm Claudia Bester, the Director of Public Programs here at the Hammer Museum, and it's my pleasure to have you all here tonight for our Hammer Forum. Thank you. The Hammer Forum is a monthly series of discussions about current social and political issues, and it's made possible with support from the Rosenblum Family Foundation. And I want to express my gratitude to our co-presenters at the Safeguarding Democracy Project at UCLA Law. Tonight, we are discussing the recent Supreme Court rulings on major issues, putting the court once again at the center of momentous legal, policy, and constitutional debates. We've gathered an all-star panel of legal scholars to analyze the meaning and implications of the latest Supreme Court opinions and emergency docket rulings. So I'm going to very briefly introduce our distinguished guests so that they have as much time as possible to discuss these important issues. Jennifer M. Chacon is the Bruce Tyson Mitchell Professor of Law at Stanford University. Carrie Franklin is the Director of the Center on Reproductive Health, Law, and Policy and the Faculty Director of the Williams Institute at UCLA. Justin Levitt is a Professor of Law at Loyola Marymount University and was the White House's first Senior Policy Advisor for Democracy and Voting Rights from 2021 to 2022. Eugene Volokh is the Thomas M. Siebel Senior Fellow at the Hoover Institution at Stanford and just retired from a 30-year career at the UCLA School of Law, where he served as a Distinguished Professor of Law and Distinguished Research Professor and is now Professor Emeritus. Our moderator this evening is Rick Hasson. He's a Professor of Law and Political Science here at UCLA and Director of the UCLA Law School's Safeguarding Democracy Project. He is a nationally recognized expert in election law and campaign finance regulation and co-author of the leading case books on election law and remedies. After tonight's discussion, we'll have a chance to continue the conversation over some light refreshments in the theater lobby. So now, please join me in welcoming Professors Jennifer Chacon, Carrie Franklin, Rick Hasson, Justin Levitt, and Eugene Volokh.
Good evening, everyone. Thanks for coming out for this Supreme Court term in review. In some ways, this term has been a tale of two terms. One term, the usual business of the Supreme Court, where it decides maybe a year in advance it's going to hear a case, leisurely takes briefing, has an oral argument, and months later issues an opinion. And the court's emergency or shadow docket, where it is deciding things on the fly, sometimes giving reasons for its decisions, sometimes not. Many of these cases involving controversial Trump administration policies. We're going to talk about both of those, the two Supreme Courts today. We're going to start by talking about some of the major decisions that the court issued through its regular process, although even some of the cases we'll talk about at the beginning are cases that were issued in this on this emergency basis. And then we'll turn to talk about what's going on now and the relationship among the court, the executive branch, and Congress, and what this means for our democracy, which is a topic that all of us, I'm sure, would like to learn more about. And so we've got a great panel today. What I've asked each of our distinguished panelists to do is to talk for about 5 to 7 minutes on a topic or a case or a set of related cases on a particular topic. And then we'll work our way down the line, starting with, just so everyone knows, it's Carrie, Eugene, Jennifer, and Justin. And after that, we'll turn to a more conversational mode, and I'm going to start by talking about that, the cases, including cases as recently as yesterday, where the Supreme Court gave the green light to the potential dismantling of the Department of Education. So we will be getting to all of that. But we're going to start by talking about some cases involving transgender rights. And Carrie's going to lead us off by talking about a case called Skrmetti and some related issues. Thanks.
Hi, everybody. Thanks for coming out here. It's great to see you. I am going to talk about a case called United States v. Skrmetti. This case was decided recently by the Supreme Court and involved a Tennessee law that banned gender-affirming care for minors. Let me tell you a little bit about the law so that you can understand what the court did and didn't say. So the law in Tennessee said no puberty blockers, sex-related hormones, or surgery for gender-affirming purposes for people under the age of 18. We had a couple of transgender kids, their parents, and a doctor challenge that, saying it violated the Equal Protection Clause of the 14th Amendment and violated the parents' rights to direct the upbringing of their children. The surgery question got knocked out of the case pretty early because none of these kids were looking for surgery, had surgery, so the court said, have standing on that surgery question. So the challenge is, can Tennessee ban gender-affirming care for minors with respect to puberty blockers and cross-sex hormones? Here's what the Tennessee law says. It says these puberty blockers and sex-related hormones are prohibited if the prescriber is prescribing, administering, or dispensing these drugs only for the purpose of enabling the minor to identify with or live as a purported identity inconsistent with the minor's biological sex, or for treating purported discomfort or distress from a discordance between the minor's biological sex and the asserted identity. And the stated purpose of the law was, quote, to encourage minors to appreciate the sex they were born into and to prevent them from becoming disdainful of their sex. So what's one thing that's interesting and legally relevant about this law is that the vast majority of times that puberty blockers and cross-sex hormones are prescribed in Tennessee, they're to cisgender kids. These drugs aren't that uncommon. They are prescribed for things like, quote, and the law exempts treatment of congenital defects, disease, precocious puberty, disease, or physical injury. So these drugs are still being prescribed frequently in Tennessee for minors, but only for purposes that are to bring the minor's body closer to the sex they were identified at birth. If you are using those drugs to take your sex in the other direction, that's what's prohibited. Okay, so you have conditions, just to be clear before I get to the law, conditions like hirsutism. This is when girls grow facial hair and body hair in other parts of their body. They can get the drugs to bring their gender more in conformance with norms. Boys who have gynecomastia, where they grow breast tissue, can get treatment to surgery to remove that breast tissue. But if you're trying to move your body the other way, you can't get it. Okay, so the plaintiffs say this is an equal protection violation for 3 reasons. 1, the law discriminates on the basis of sex. 2 kids come into the doctor's office and they both want to remove breast tissue. The boy can do it and the girl can't under Tennessee law. So they say this should get heightened concern from the court. The court should take a closer look because it discriminates on the basis of sex. The plaintiffs also say it discriminates on the basis of transgender status. Cisgender kids can get these drugs for all the conditions that I just talked about. Transgender kids cannot get the drugs. And the plaintiff said you should take a closer look for that reason too. And finally, the plaintiff said this law is based on animus. Tennessee leads the nation. They passed about, in fact, double the number of anti-trans laws that other states have passed. They got bathroom bills, they got drag bills, they got schools have to report if your kid is transgender, they have to tell the parents. They have all the laws that you've heard about in the paper. They've got about twice as many as other states. And so the plaintiffs are saying this law is part of that campaign. It's based on animus against this vulnerable group of people, and that's never a legitimate constitutional reason to pass law. So, as I mentioned before, they also argue that parents have a constitutional right to direct their upbringing of their own children. The plaintiffs said the American Medical Association, the American Academy of Pediatrics, the American Psychiatric Association, the American Psychological Association, the American Academy of Child Adolescent Psychology, and all the leading medical organizations in the U.S. approve the use of gender-affirming care when it's indicated for minors. So the parents argued this should be left to us and our doctors, not the legislature in Tennessee. They got to the Supreme Court on the equal protection claim, but the court did not take up the parents' rights claim. Okay, Supreme Court rejected all 3 equal protection claims. The court said, no, this law does not discriminate on the basis of sex because both boys and girls are prohibited from getting gender-affirming care. Purpose, use of these drugs, and both boys and girls can get the drugs for other purposes. And so there's no line being drawn between boys and girls, no sex discrimination. They similarly say, no discrimination, this law does not discriminate on the basis of transgender status. Transgender and cisgender kids can get the drugs for precocious puberty, for hirsutism, for gynecomastia, for any of the other conditions in which they're allowed in Tennessee, and no one can get them for gender-affirming care reasons that affirm your gender in a way that doesn't accord with your biological sex. So they're not drawing a line on the basis of transgender status. And finally, the court says there's no animus here. Legislators feel that this is an unproven medical treatment and they are looking out for the kids. That's a perfectly good reason to pass a law. So we don't have a constitutional problem on the constitutional question we took. So I'll just finish with implications of Skrmetti. I will say two things that point in different directions. One, it's interesting, I guess as a lawyer, I feel like saying this could have been a lot more broadly decided. They could have said this is sex discrimination and that's okay. They could have said this is discrimination against transgender people and that's okay. There were concurring justices who did say those things and wanted that to be the holding in the case. The court did not say that. The court said, I think somewhat unpersuasively, but nonetheless, that this is not sex discrimination, this is not transgender discrimination, this is discrimination on the basis of age, and this is discrimination on the basis of medical treatment, and the state is allowed to make distinctions between minors and adults, and it's allowed to make distinctions among different medical treatments. That's all that's going on here, nothing much to see here, folks. If you look at it like that way, maybe this doesn't have huge implications for all of the cases you're seeing in the newspaper, the sports, the bathrooms, the adult medical care, all that kind of stuff. As a lawyer, I can distinguish the holding in this case from all of those other cases. However, very recently, post-Skrmetti, the Supreme Court looked at 4 appellate court decisions. One was involving birth certificates. These are all transgender cases. One involved birth certificates. One involved public school teachers' medical programs covering transgender care, and one involved Medicaid covering transgender care for adults. And the court, and all of those 4 cases, the lower court found for the transgender plaintiffs. A few days ago, the Supreme Court vacated all of those decisions and said to those lower courts, you need to go back and reconsider your decision in light of Skrmetti. Now, I just said, but Skrmetti doesn't maybe apply in those other circumstances. This is a pretty strong signal that maybe the court thinks it does apply beyond the 4 corners of the decision. 2 more things. The court just granted cert, some of you may have seen, in 2 cases involving sports. They will be heard this year and they will be decided next summer. Maybe we can talk about them exactly 1 year from now. These are cases out of Idaho and West Virginia where the states said transgender girls may not play on girls' sports teams from kindergarten through college. The Idaho law says any individual in the state can challenge a girl on a team and she will be subjected to sex testing, including gynecological exams, if anyone thinks she might have been labeled male at birth. This only applies to girls' sports, that transgender girls cannot play in them. The plaintiffs are arguing that this is sex discrimination. They won below, but the Supreme Court granted cert. I do not think the trajectory is in the direction of the transgender plaintiffs, I will say. And then my final word, which transitions to Eugene, is they also did not take up, the parents in Tennessee said, okay, well now we want to bring our parents' rights claim to the court. And they lost below on that. The lower court said you do not have any constitutional right as parents to make this decision for your kids. The state can legislate in this way. And then they let that decision stand. So they found that this is something that the state can decide. The parents don't have a right to make these medical choices. Eugene's going to talk about some parents in a related case that fared better than the parents in my case.
Thanks, Gary. You covered a lot of ground in a very short time. I appreciate it. And I am going to want to come back to you later and ask you about Justice Barrett's concurrence, which you briefly mentioned, and the implications of that. But we're going to work our way first down the line. And Eugene, and among the many things that he is an expert in, is the First Amendment. And there were some important speech and religion cases, and he's going to address a few of those.
Great.
Hold the mic.
Sorry, I'm going to talk about two cases that are, in some respects, very old. Just as this was an issue that's very new, these were issues that were very old. I'm not going to talk about one new case, which is TikTok, because that was in January, which is like 20 in modern Supreme Court years ago. It's like, who even remembers that? So I'm going to talk about Free Speech Coalition versus Paxton and about Mahmoud versus Taylor. So Free Speech Coalition, upheld by a 6-3 vote, sort of the same conservative-liberal split, upheld a state law that basically requires age verification for online porn sites, sites that had at least 1/3 pornographic material. And here's the backstory. So first of all, this issue had come up to the court before in 1968 involving brick and mortar stores, and then in 2003, I think, involving the then internet, also quite different in some respects than the modern internet. And the court held different ways there, so it had to really resolve this tension. And it resolved it in favor of age gating. So here, let me just give you the very quick rundown of the underlying legal regime. Most pornography, at least these days, is legal for adults. Technically, the government can ban certain kinds of porn, even for adults. But, you know, the war on pornography is over and porn has won, at least where adults are concerned. So as a practical matter, adults have the legal right to access a great deal of material. But back in that 1968 case, the court has said, and has since reaffirmed, that minors don't have a right to access pornography, at least material that's obscene as to minors is the technical term. They have the right to access a good deal of material, including some that touches on sex, but not pornographic material. So there is this zone of material, pretty large zone, obscene as to minors material that's legal for adults, and but that's constitutionally protected for adults, unprotected for minors. And the court says, so the challengers say, well, this is a restriction on speech based on its content. The speech is protected for adults. This law does interfere in some measure with the rights of access for adults. It makes them more hassle, maybe a bit more expense, and also interferes with privacy of access, because you've got to be able to identify yourself, possibly by showing your ID to the internet camera and such. So it's burdens speech, so therefore it should be subject to so-called strict scrutiny, a pretty demanding test. And the court says, well, actually, when it comes to material that's constitutionally protected for adults but not for minors, the government gets more latitude. So it gave some examples. Guns. Guns are constitutionally protected for adults, but not for minors. What does that mean? Well, you can card people if they want to buy a gun to check various things, including their age. Another example is voting. Voting is at least constitutionally protected as a state constitutional matter. Interesting question as a federal, but basically protected. That's there. You can make sure that the person is indeed an adult. Right to marry. Adults have a right to marry, children don't. As a result, the court says we're not going to apply strict scrutiny here, we're going to apply intermediate scrutiny, which is a less demanding standard. So interestingly, the dissenters, in an opinion by Justice Kagan, say, well, no, we should apply strict scrutiny. But, we're not saying this law would fail strict scrutiny. Such an important interest in protecting minors from sexually themed material, maybe a properly crafted law can pass it, but, it takes a lot to do that. And the majority says, no. Strict scrutiny really should be super duper mega strict. All the more reason not to apply it here. So the majority and the dissent both say they're trying to protect speech, even though the dissent here would be more speech protective in this case. The majority says more broadly would be more protective, because we want to apply we want to save strict scrutiny as a super strict test for most speech, just a somewhat narrow range of speech. Whereas the dissent says, well, we want to have strict scrutiny cover a broader range of speech, but perhaps provide somewhat less strong protection. So that's the dispute there. Now let me turn to Mahmoud v. Taylor, which is a free exercise clause case. So for basically 60 plus years, the court has been debating the question of whether religious objectors should get exemptions from generally applicable laws. Could be drug laws, could be various employment laws, could be requirements that you be available to work any day of the week as a condition of unemployment compensation and such. 1963, the court said yes, in an opinion by Justice Brennan. At the time, it was seen as a very liberal position, pro-religious exemptions. In 1990, the court reversed course, in an opinion by Justice Scalia, saying no, free exercise means freedom from targeted discrimination based on religion, but religious objectors have to live with the same laws that everybody else does. That was seen as a very conservative position. And Justice Brennan was in the dissent there. So I oversimplify slightly, but it was basically the liberal ACLU position in favor of religious exemptions as a constitutionally mandated matter. Not in every situation. Obviously, some laws you don't get exemptions from, but a strong presumption, again, subject to the strict scrutiny test. Whereas conservatives said no special rights for religious objectors. The interesting thing is, from recent opinions, it looks like the ideology on the issue has flipped 100%. Conservatives are now in favor of religious exemptions, and liberals are against it. So conservatives are taking up Justice Brennan's cause, and the liberals Justice Scalia's. So it was thought that maybe this case would actually raise this very issue in the big picture scheme, because what was happening is that parents were saying, and this is religiously conservative parents, a Muslim couple, a Catholic couple, and then a couple which is mixed Catholic and Ukrainian Orthodox. They said, we want an exemption from, an opt-out of our kids from certain books in their actually very early grade reading assignments, that the books were deliberately had characters that were gay and lesbian and transgender. As a means of trying to kind of convey acceptance of different. There you go. Props. It was heavily illustrated in color. The books, the opinion was. It's unusually visual as opinions go. So I appreciate seeing these props here. So in any event, the court did not decide this big picture question of religious exemptions. It didn't say, oh, there's a general right to religious exemptions. Rather, it said, this is a special case about, indeed, parental rights, but not parental rights writ large. It turns out, I think parental rights as to medical care are actually quite a bit narrower, and maybe we'll talk about that later. But parents have a presumptive right not to have their kids be taught things that undermine their religious teachings. It's all about teaching. Not general parental rights, but parental rights to control the kids' teaching that bears on their religious beliefs. There was an earlier case, Wisconsin v. Yoder, which involved the Amish and exemption from compulsory education law into high school. Well, that, though, involved compulsory education, where the sense that you had to send your kids to school. Here, this was actually a claim of exemptions from public school curriculum, although there too the claim was we have to send our kids to school, we may not be able to afford to send them to private school. Well, the court said there is a presumptive right to exemption from these kinds of, not even these kinds, any kind of curriculum items that you feel interfere with your, sincerely believe interfere with your religious teachings. So it wasn't limited to gay and lesbian and trans themed things. It would cover presumably people who have objection to teaching that is to teaching of evolution. May cover people who have objections to teaching of patriotism. I know some Jehovah's Witnesses may have such objections. May cover perhaps pacifists' objection to teaching that they see as glamorizing war. Could be a very long list of things. So potentially quite a substantial would be quite a substantial impact on many schools, which will have to deal with these opt-outs. Although the court did mention that modern public education already requires a lot of opt-outs, whether for English as a second language or for individual education programs and such. So didn't resolve this big picture Scalia versus Brennan question, but did say that there is a presumptive right of parents to exemption of their kids from teaching, including purely secular teaching, that they see as interfering with their kind of religious messages to their kids.
Thank you, Eugene. Now that we've covered the easy, non-controversial stuff, we're going to turn to the topic of immigration. And every morning I wake up and I'm glad that I'm not an immigration law expert like Jennifer is, because I don't know how you could even keep up with the reading, much less be able to form opinions on this. What can you tell us about how the Supreme Court has approached these immigration questions that have been coming to the fore since the change in presidential administrations?
Well, first, thank you for having me here, and it's really an honor to be up here with all of these esteemed people. In answer to your question, I feel like the immigration issue brings us to the existential crisis moment, existential nationally, but also just thinking about this panel and what we do at this Supreme Court review event every year, which is usually we talk, and we've just seen sort of the traditional approach to this event, which is the kind of pick a couple of big cases in an area, talk about those big cases in an area. So in past years when I've spoken on panels like this, United States versus Arizona, a big federalism case that came out of Arizona, or Trump versus Hawaii, right? Those big merits decisions sort of adjudicated through traditional mechanisms, working its way up to the Supreme Court, where oral argument is heard by the court and where you get a reasoned opinion, whether you like it or don't. It's a reasoned opinion that the court gives you about the case. And if I were doing that in immigration today, I would be talking to you about Riley versus Bondi, and you would yawn, and you would, maybe take this opportunity to go to the restroom. It's interesting to immigration lawyers, but it was not a headline case, and it isn't something probably that would be useful on a panel like this. And so it's interesting that when Rick asked me to talk about immigration, what I'm looking at and talking about and thinking about is not the big merits cases, but instead the emergency docket or shadow docket cases, which is where the Supreme Court has done most of its work in immigration. And so, as I'm sure we'll talk about more, we've seen an extraordinary number of pitches by the Trump administration to the Supreme Court for emergency relief. The Supreme Court has granted emergency relief in 20 cases since January. So this is sort of an extraordinary number of interventions on the part of the Supreme Court, sort of jumping the line in terms of procedure, so we're not watching cases work their way up to the court, and also being decided in ways that look very different, and in all of the cases that I'm talking about, really not having a long reasoned opinion from the majority of the court justifying the decisions that it's making. So that, I think, raises questions about what we do here, how we handle this. We usually talk about this as a Supreme Court in review panel, but the Supreme Court is still going. The October term is not over, and even as we sit here, things are percolating up to the court in this emergency way. And so I think one of the questions that we'll probably want to wrestle with is maybe what this means for us, but certainly what this means for the court and what it does. When we look at immigration, then the things that are interesting are these emergency docket interventions. The first that I was going to talk about was the Abrego-Garcia case, which probably most of you have been following or have heard about. This is a case involving Guilmar Abrego-Garcia, who's a national of El Salvador. He's been in the United States for some time now. He entered without authorization, but he, in 2019, was granted withholding of removal, which means that there's a court order that says that he cannot be removed to his country of nationality, El Salvador, because there's a likelihood that he will be persecuted on one of the grounds that are protected by international and domestic law. So he's not supposed to be removed to El Salvador. And yet, as you may have heard, he was. He was part of a group of people, I'll talk more about some of the other people in that group in a moment, who was removed to El Salvador, placed in a Salvadoran prison, Secot, and wasn't supposed to be there. And so there was litigation over, his lawyers filed lawsuits. There's an effort to get him out, and the Trump administration was taking the position before the district court that actually they had no control. He was in El Salvador, and that's the breaks. And Judge Zines, District Court Judge Zines, was not impressed with that answer and said that she wanted them and ordered them to facilitate his removal or his return to the United States, so that any removal could be considered in a normal way, in a procedurally appropriate way. And the Trump administration was really resistant to this idea that they could or should bring him back. They raised the argument that this is a sphere of foreign policy, that this court shouldn't be involved in this at all. And this is one place where the Supreme Court intervened in a way that was affirming of the district court's order, and the Supreme Court ultimately said that yes, indeed, while they said that Judge Zines needed to recraft her order in a way that made it clear that the court was not trying to interfere in foreign affairs matters, the Trump administration, she could indeed order the Trump administration to facilitate Abrego Garcia's return to the United States. And so the matter returned to the district court. Further shenanigans unfolded. You've probably heard about some of these things. Real questions about what the Trump administration's authority was over Abrego Garcia and whether they could bring him back. He is now back and facing criminal prosecution for smuggling charges that the Department of Justice has now brought against him. He's detained in part because there is concern that if he's released from detention, then ICE or DHS could remove him again, and so he's now awaiting criminal prosecution in that case. Relatedly, there are a number of cases that relate to individuals who have been removed by the Trump administration pursuant to the Trump administration's purported authority under the Alien Enemies Act. And so the Trump administration, or President Trump, issued an executive order where he claimed that the Tren de Aragua gang, all of the members of the Tren de Aragua gang from Venezuela were alien enemies who were invading the United States, and that gives him extraordinary powers to remove them outside of the bounds of sort of normal immigration processes. And as a consequence of this order, we saw the Department of Homeland Security identify a number of Venezuelan migrants as Tren de Aragua members and remove them to Secot, the same facility where Abrego Garcia was removed. And so we have Venezuelan nationals removed without process and in a Salvadoran prison. And this is another case where we saw the federal district court judge, in this case Judge Boasberg, ordering the administration to, first of all, not remove these individuals on grounds of the Enemy Aliens Act without proper process. And second, when those individuals are removed seemingly in violation of his order, ordering them to return those individuals to the United States and to ensure that they had appropriate process. And here the Supreme Court intervened to clarify the way in which individuals had to seek court protection, and said, if you're going to challenge the administration's removal of individuals under the Alien Enemies Act, then you need to bring these proceedings as habeas proceedings. And so the court affirmed that individuals should have access to process here. They should have notice, and they should have some opportunity to be heard. The appropriate vehicle for bringing these challenges, the court said, is habeas actions. There are a variety of reasons this is interesting and not, and somewhat surprising given some of the court's decisions just a couple of terms ago. It's not clear that habeas is the right course of action, but that's probably more in the weeds than we want to get. But the court said that's the right way, and that's how we should proceed. And one consequence of this is we have individuals who are still in Secot, who have never, at this point, had a hearing as to whether they are in fact members of Tren de Aragua, let alone have we had any sort of formal decision on the question of whether Tren de Aragua members can be designated alien enemies under the Alien Enemies Act. It's worth noting that the Alien Enemies Act has only been invoked 3 times in the history of the country, the most recent one being during World War II, when it was invoked as against Japanese, German, and Italians who were residing in the United States. And during that time, you might remember, the United States was at war, a declared war, an awful and long-standing war with Japan, Germany, and Italy. So the facts look very different from this invocation of the Enemy Aliens Act. And so, again, the Supreme Court has intervened at the procedural stage, but we haven't really gotten to the meat of the kinds of claims that we might expect to see, and the individuals who have been removed are still gone and awaiting proceedings. There have been a number of people, I should say, who have been sort of in the process of being removed, and various district courts have issued orders that have prevented those individuals from being removed from the country. But lots of litigation still remains to unfold. And the final thing that I'll note is the DVD case, which involves the removal of individuals to third countries. So when you take some, kind of like what happened to Abrego Garcia, or sorry, not to Abrego Garcia, but to all of the other individuals who are designated as alien enemies who have been removed, who are Venezuelan, but who have been removed to El Salvador. But in this case, it involved individuals who were not being removed under any alien enemies order, but who had criminal convictions that rendered them removable, and they can be removed rather quickly under an expedited removal process that the statute provides for. The problem is that the administration decided to send these individuals to South Sudan, and none of these individuals are from South Sudan. And so they said, wait a minute, we don't really think you can do this without a process. There are processes in the statute for removing individuals to third countries, but none of those processes appear to have been followed in this case. And so they said, this is wrong, you can't just willy-nilly remove us to a country that's not our own, and for which we've had no process. And this is another case where the district court issued an order that said, don't remove these gentlemen to South Sudan. And the planes left, and the court ultimately came back and said, now that the individuals are sitting in Djibouti, about to be sent across the border to South Sudan, you really need to give them a procedure. So it kind of happened in 2 stages. One was that don't send them. And that order happened in April, and then in May there was well, now that they're there, give them some process. And the Supreme Court intervened at 2 points here. The first was sort of responding to the don't send them order, and they said, wait a minute, you can't issue that order. So they stayed that don't send them order. And then the case sort of percolated back up because the judge was insisting that his May order, which says, well, now that they're there, they get process, he said that's not really subject to the Supreme Court's action on the first order. And the Supreme Court came back in a 7-2 decision, in which Kagan joined the conservatives. This is the only one that has this configuration, where they said, well, if the first order is no longer in effect, then this second order can't be in effect either. And so ultimately, these gentlemen are in Djibouti without process, and that's sort of where the Supreme Court's intervention has ended. There have been a couple of other immigration issues that have gotten before the Supreme Court. They involve the rescission of TPS for large numbers of Venezuelans, and the rescission of humanitarian parole for large numbers of people from Cuba, Nicaragua, Honduras, Venezuela, and also people from Ukraine and Afghanistan. Hundreds of thousands of people affected by these rescissions of protections that were previously extended by the Biden administration. Litigants took the position that until a decision was made on the merits about whether these rescissions were appropriate, they should be allowed to retain their status, that is, that the orders rescinding should not go into effect. The Supreme Court has intervened to allow those rescissions to go into effect, and so people have lost their status as the issue of whether those changes in their status were illegal remain ongoing.
Thank you. Your whirlwind tour, or abbreviated tour, shows the difficulty of trying to use courts in real time to police some of these things. Which brings us to Justin. When I initially invited Justin to this panel, I thought he was going to be talking about a major voting case that the Supreme Court, surprisingly at the end of the term, decided it wasn't going to decide this year.
Oops.
It's going to kick it to next year for reasons they haven't told us yet, but promise they will. But instead, we're going to talk about another case that came up in an unusual process, but that got a full hearing involving birthright citizenship and related issues related to executive power. So,
yeah,
Justin.
and this first case I want to talk about could really have been in Jennifer's bucket, and it's so many of us here are dealing with very similar trends at the court and very similar processes in very different substantive areas, which is why there'll be a whole section on this second term. My cases bridge this gap a little bit. One, they both came up in emergency postures. One was resolved after sort of kind of full briefing-ish, and the other one wasn't. The first one I'll talk about is the birthright citizenship case, which involved a decision that did not in any way address birthright citizenship. On January 20th, along with several executive orders that have affected many of the cases you've heard about so far, President Trump issued an executive order purporting to rescind birthright citizenship for individuals who are born to people who are not citizens or legal permanent residents, but were born in the United States. The Constitution says, and I think this is fairly uncontroversial, can't do that. Everybody sued, and all of the courts started issuing orders or started issuing various forms of process sort of confronting this. The case as it came to the Supreme Court didn't involve the merits of that decision at all, and that actually is one of the problems that I hope we'll get into. Instead, the court tackled a very procedural issue that nevertheless has huge ramifications, and that is the propriety of getting relief that extends to somebody other than the person who brought the case. So normally, you may think that when you sue somebody, that the job, if you win the case, the job of the court is to make you whole. If Carrie sues me and she wins, then the job of the court is to make sure that Carrie is made as whole as possible. And it doesn't matter if there's additional relief that Rick happens to benefit from, or that Jennifer happens to benefit from, or Eugene happens to benefit from. This is a dispute between us. And that's true even when the government's involved. And that's effectively what the Supreme Court said. And so there's a part of what the Supreme Court said, as Carrie said before, sort of as a lawyer, where this makes all the sense in the world, that if you want to bring a case that has ramifications beyond just you can do it as a class action lawsuit. There are certain avenues that by statute allow you to vacate a decision for everybody, but the normal sort of regular course is you bring a case, and if you win, the person that you're suing has to respond to make you whole, but doesn't have to stop what they're doing for everybody else. That's what the court decided. It is still a really big deal that they decided this, how they decided this. The methodology included some founding era history that is becoming increasingly prevalent, but no more concrete than it has been in other areas where people have been very critical of the history of the court. So we've seen this in the Second Amendment in years past. We've seen this in the context of Dobbs and reproductive freedom in years past. This is another case that turned on founding era history and a lot of controversy over the determinism and also the accuracy of that history. The decision came without any mention of the merits, and there was a lot of critique on that. Some constitutional issues are legitimately hard. Many constitutional issues are legitimately hard. I don't think this is one of them. And for the court to not, as at least a glancing blow, mention that the Constitution and history and precedent and all of the methodologies that you may care for all point in exactly the same direction here, which is you can't do that. For the court to issue this opinion without mentioning the merits at all was highly controversial. And the timing in particular was especially controversial. Not only the notion that there have been an increase in these sort of national injunctions, not just you stop for me, but you stop for everybody, for several presidential terms now, and the court has sort of waited until now to resolve this issue. But they've waited for an administration with, as I think Jennifer extremely politely put it, a curious approach to the rule of law flat out. This, in what I'll say, an administration with more regard for the rule of law, you would expect that when the courts reach consensus on an issue, that the government would say, okay, we see the courts have decided this, we're not going to do the thing anymore because we recognize that's unlawful. This administration seems uninclined to listen to what courts generally are saying without a direct court order, and as Jennifer just mentioned, seems uninclined to listen to what courts are saying sometimes even when there is a very direct court order. So for the Supreme Court to put up this sort of procedurally straightforward, but nevertheless leaving room for permission for this administration in particular to play some games with exactly who has told them what, when, and where, seemed not apt for the times in which we live, or the demonstrated record that this government in particular has brought to litigation in which they've been involved. That said, there's actually a tiny bit of upside. This opinion, I think, will have massive consequences for other cases, for lots of other cases. I don't think the opinion will actually have much of an impact at all on the birthright citizenship case for several reasons. One, the rules are a little bit weird about what it takes for a plaintiff to get relief when states are involved, and there are many states involved. The rules are a little bit weird when states get involved in immigration cases where people move around, and what it means for a state to be involved in these sorts of cases may well mean national relief, even if just one plaintiff or just one state is at issue. There are procedures for aggregating claims, class actions, and in this case, the class action's really simple. I was born here, and everybody who was born here is similarly situated to me, and so we can all bring the claims in one shot. And there's a provision in federal statute for challenging government agency action that absolutely none of this case affects at all, and all of those seem very relevant in addressing birthright citizenship. I don't think this is going to play a role. That one statute for addressing agency action has been used 60 plus times since this administration took office to stop federal action. That is an extraordinary tally in July 15 of a first term of a presidential year. So there's still quite a bit of potency in stopping federal action that I think this particular case won't regulate one way or another. But the methodology is a big deal, and its impact on other cases is a very big deal. Very briefly, I just want to touch on the administrative state and some of the action involving one of the other cases involving presidential unitary executive theory. A lot of what we've been talking about has to do with the force of the president's authority and how much Congress or other bodies can restrain that. We all know Constitution authorizes legislative activity, authorizes executive activity, authorizes judicial activity, doesn't have a lot to say about administrative agencies, which sit sort of in the middle of all three. They exercise a little bit of all of these powers. The Constitution acknowledges that agencies will exist. It doesn't say a lot about them. It says a tiny little bit about hiring people who run these agencies, but even that is maddeningly imprecise. It doesn't say anything about firing them. And so all of the law in this area is really court-made and invented out of principles that have to do with the separation of powers. Those principles are pushing back against what Congress has said these agencies are supposed to do. Congress has set up all of the agencies. Some of them they've made directly responsible to the president, things like Department of State, Department of Defense, Department of Treasury, Department of Commerce, very direct line to the president. Others, Congress has made more independent, including multiple members who lead the agencies, including staggered terms so that no one president appoints all of the members of the agency, including provisions that say you can't get rid of somebody unless you have cause. You can't just fire them because. So there's some pushback. Congress has set up these agencies with independence. The court is trying to figure out where in the constitutional structure this congressional authority lies and how much it can take from the president or not. This has to do with the push and pull of what's sometimes called unitary executive theory. Exactly how much can Congress interfere with, or if you're a congressional scholar, set up the rules for these agencies that they empower. And on the scale of unitary executiveness, I think it's fair to say that President Trump is way toward the end of what it means to be a unitary executive. Somebody who says, "I alone can fix it" as a campaign slogan doesn't like to think of many plural executives running around. So Donald Trump took office. He fired essentially everybody. It's his catchphrase, and he used it. There are at least 11 different independent agencies where the heads were fired and sued, saying you can't do that. Congress said, I cannot be fired except for cause. And 2 of those made their way to the court, really important because they have to do with personnel agencies, the heads of the National Labor Relations Board and the head of the Merit Selection Protection Board, which is the agency that says if federal officials get fired improperly or get disciplined improperly, that's where you go for relief. And Trump fired the head of that office. Those were entities that Congress had designed to be independent from presidential control, where district courts had said, you're right, give them their jobs back, and where the court on the emergency docket, rocket, no briefing, very little briefing, 3 sentences in the majority opinion explaining why, said, you know what, let's put that on pause for a second, and have allowed these firings to take effect and allowed these offices to remain vacant without really handing down a rule, except a shadow of what is to come, and signaling in those 3 sentences a pretty dramatic reevaluation of the power that Congress has to insulate certain executive agencies from presidential control. In many of these cases, you've seen Justice Sotomayor and Justice Jackson dissenting. This one sparked a raging dissent from Justice Kagan, who's an administrative law scholar. And I have to say, I find her 16 pages of explanation more convincing than the 3 sentences in the majority. But I hope we're going to get into the whole fact of that emergency docket, this second term that Rick talked about, because I think that's a feature in every one of the areas that you've talked about today.
Thank you. All right, so now I want to open it up a little bit to talk, and I should say that we will leave time at the end, the last 10 or 15 minutes, for audience questions. I want to turn to what I think is the biggest question, which is the relationship between the Trump administration and the Supreme Court. And I read 2 interesting things today on this topic. The first thing I read was an interview by the New York Times opinion editor David Lenart with Michael McConnell. Michael McConnell is a professor and former 10th Circuit judge, conservative judge. And he said, the courts have done a pretty good job so far given their institutional capacity. And really, the founders thought that it was Congress that would be checking the president. That separation of powers, that would really be Congress. And he said, in both Democratic and Republican administrations, we have what Professors Pildes and Levinson call separation of parties, not powers. So if Republicans control the Congress and the presidency, there's no check. If Democrats control both branches, there's no check. And so I take McConnell's position that we're really expecting too much of the courts. So that was one thing I read today. The other thing I read today was on Sherrilyn Ifill's Substack. Sherrilyn Ifill's a former head of the NAACP Legal Defense Fund. She's a professor at Howard University. And she was writing about the McMahon decision. So this was a decision that came out, is it yesterday? I lose track of time. That says that the Supreme Court is allowing Trump to dismantle the Department of Education, in the interim while the issue is being decided on the shadow docket. And unlike the 3 sentences Justin referred to in the earlier case, there were no sentences given, no explanation given. So here's what Sherrilyn wrote on her Substack. My conclusion a year later about the relationship between Trump and the courts is simple. We must with clear eyes confront the only reasonable explanation for the actions of the conservatives on the Supreme Court over the past 2 years. The conservative majority on this SCOTUS is fully aligned with President Trump's vision of his executive power, not because they're up to something or because of moneyed interests, but because the conservatives on this court have come to genuinely embrace the MAGA vision of Trump's presidential power. They are aligned with his claim to unfettered executive power, and they don't intend to restrain him. Precedent to public interest, the integrity of lower courts, and I fear even the Constitution must yield, they believe, to that vision. So 2 very different views, one I think giving the court an A, the other giving the court an F. And I wanted to just get some views of the panelists. We've got certainly an unprecedented situation where this president has gone to the Supreme Court for emergency relief more than the last 4 presidents' administrations combined. And yet he's winning almost all of his cases. So what can we learn from all of this? Justin.
So I was with Lenhart in the Times in saying the courts, plural, are doing a pretty good job. And I think they really are. And I think that's independent of which party happened to appoint them to their positions and independent of their Senate confirmations. Trial courts and appellate courts, I don't agree with every decision, but they more or less seem to be acting as courts. The Supreme Court is not. It's acting as a power center. When it delivers rulings that impact people's lives, and the only explanation they give is, or, that's something we expect from an emperor because they can, not something we expect from a court whose job is to explain itself and yield prescriptions that other courts follow. So I give the trial courts and appellate courts, given the tools that they've had, something close to an A. I give the Supreme Court on its regular merits docket pretty mixed reviews. I give it a flat F and easily for its use of the emergency docket because what it's doing isn't law, and it's a body whose job is to do law. Congress, I'm not even sure, is showing up for class. I don't know how to grade. It used to be that members of the budget committees would go home to their constituents and explain to their constituents that they are the most powerful people in Congress because they decide where all the federal money goes. And then the president and Elon Musk showed up and decided to make different decisions, and Congress didn't raise a peep about that very strong, very clear Article 1 prerogative. And that is mystifying to me. That's not, they are not functioning as a Congress, so I don't know how to grade whatever it is we've got that meets on Capitol Hill, because it's not a legislature at this point.
Whoa, okay, so I think I had a similar reaction to Professor McConnell's opinion as you, which is courts, yes, lower courts are cranking out thoughtful opinions, finding facts, working hard, making judgment calls that are reasoned about whether the administration's actions are lawful or not. And by and large, they're finding them not. I mean, the statistics are pretty damning. And then the Supreme Court's intervening, and this is where I think maybe if they wanted to do a good job, they would do less, right? Let things percolate, let things get to the court. That doesn't mean that they should never be intervening, but it does make me wonder about the 20 interventions that we've seen over the last 6 months. It seems extreme, and it does suggest that something other than the normal operation of the institution is occurring, and maybe this is just the new normal. But it is interesting that the kinds of emergency relief that we're seeing the Trump administration get is not on all fours with the kinds of emergency relief we saw in the Biden era. It's all, you kind of can compare and contrast some of the cases, right, where it was beyond the Biden administration's power to freeze student debt, but it is within the Trump administration's power to dismantle the entire Department of Education. So the lack of parallelism does lead to some troubling questions. I think that I wanted to go to the Sherilyn Ifill column from today, which I thought was worrisome because part of the sort of import of her column is that she is increasingly less and less sanguine on the birthright citizenship case. She says the fact that they said nothing should tip us off that there's more to worry about than perhaps we are. She doesn't think it's inevitable that the court will, if they decide this issue on the merits ever, that they will decide that the Trump administration has the power to strip citizenship from certain individuals. But she does think that it's more likely than she would have said it was a year ago. And there she really sort of speaks to the need to mobilize democratic opinion on the issue, because the court is in some ways doing something other than judging, and popular opinion on this issue matters. And it suggests that the sort of role for people to push back, to learn more, to understand better the legislative history of the 14th Amendment and the justifications for the amendment that sort of undergird multiracial democracy are very, very important in this moment. And so I think it's worth lifting that up just as a through line from your comments on CASA.
Eugene or Terry?
So I don't have as much to say about some of these issues because they're largely outside my field. I did want to ask, my understanding is that when it came to the Biden administration's student loan matter, that was ultimately resolved by the court after full briefing and argument, right? So a lot of these things are are indeed orders with very little explanation, but I think it's not uncommon historically on the shadow docket to have relatively little explanation.
Yeah, but there's a massive explosion of number of cases on the shadow docket. So
That's right. So what has happened is a lot of lower court judges, I think some of them picked carefully by the plaintiff's lawyers, which is what the plaintiff's lawyer's job is, right? People say forum shopping as if it's a bad thing. No, it's your job as a lawyer, whether you're on the left or the right, to shop for forums. But my sense is what's happening is that the Supreme Court's view is, when it comes up on the merits, we'll decide it with full briefing and full reasoning on the merits, but some of this stuff is coming up on stays of orders where we think one district judge shouldn't be blocking the entirety, what the entirety of the executive branch is doing. Maybe wrong, but I think that helps explain some of it. I did want to mention one thing, which is it's a different kind of procedure about the birthright citizenship thing. I'm inclined to say, based on my limited knowledge of this, that indeed the 14th Amendment protects birthright citizenship. I actually think that birthright citizenship is a very bad idea as a policy matter. I think it's not an accident that very many Western democracies do not adopt it. I think the idea that somebody comes to America 8 months pregnant and has a baby, which, by the way, I should say, if this were my family, I would say that's a wonderful thing, right? It's a wonderful thing to do for your child. But it's not clear why, as a policy matter, that decision by somebody who before was unrelated to the United States should be, even if they come perfectly legally, should be a basis for America to provide birthright citizenship. I think the only reason to have birthrights, to have the court recognize birthright citizenship, is because the text, interpreted in light of its original meaning, the text by itself, as in with so many things, can't tell you the full answer because it has certain legalese in it that you have to understand what it means. The text is interpreted by through original meaning, says that's the law, and whether you like it or not, that's the law. I think it's a very good argument, but I think it's no accident that the arguments in favor of birthright citizenship are so originalist. If you imagine if the conservatives on the court were to adopt a living constitution view, that's not going to be very good for the defenders of birthright citizenship, because they could very well say, well, times have changed. We have different transportation, different patterns of migration. But back in 1868, nobody would come here as a tourist in the 8th month of pregnancy. Just transportation mechanisms, at least overseas, would preclude that from happening. We didn't have the same kind of rules with regard to immigration. There really wasn't much by way of illegal immigration then, because the country was constantly seeking more and more migrants. There was a labor shortage, a constant labor shortage. So in any event, I do think it's noteworthy that in this area, the people who want to take the liberal position on birthright citizenship are making very much the originalist argument, and if the conservatives were to adopt living constitutionalism, that would be very bad for the challengers, I think.
Before I give Carrie a chance to weigh in on the shadow docket question, I just want to ask Eugene, do you think that the court does a disservice when it gives no explanation whatsoever, not even the 3 sentences that we saw?
I am always in favor of more explanations. It's interesting, if you look at courts throughout America, most federal appellate courts write relatively reasoned opinions. Some don't. 11th Circuit does a lot of things through one-line judgment order, affirmed or denied. Federal district courts generally in non-procedural matters, and even many procedural ones, write relatively detailed opinions. A lot of state courts just issue, including California courts, just issue one-liners. I think it would be better, especially I think if there is a long dissent, I'd like to have somebody write along a majority or concurrence. But to me, it's actually, I always try to judge these things with an eye towards the kind of the custom of the court. And I think, even if I think perhaps the court should shift to a custom of offering more reasoned opinions in this area, my sense is that there's long been a custom that various kinds of stay decisions and other such things have been 3 sentences or fewer. But maybe I'm mistaken on that.
Carrie?
I guess I want to start by saying perhaps you all know what the shadow docket or the emergency docket is, but in case you're not clear about this is a major transformation that we are undergoing in the way that the court does its business, and I think it's worth just saying something about it, which is, in general, there's months, years of preparation that go into these cases. There are briefs written and reply briefs written and amicus briefs written, and they study them and they read them, and there's an oral argument where they listen back and forth, ask the lawyers questions. You can hear it on C-SPAN, and then there are many months of deliberation, and they publish these opinions that are so long they're hard to assign to my students because they go on and on and on, like 150 pages, but it's good. It's a lot of explanation. Then the dissent tells you why they disagree, and the majority tells you what their reasoning is. And this is important for so many reasons, but one of which is the rule of law. They've laid down their thinking and their principles and their rules so that when the next case comes along, it's not partial. It doesn't depend on who the plaintiffs are. We can try to apply the rules consistently. That's the ideal. That's the hope. That's why we get these opinions. And they serve a lot of purposes. Think about the opinion in Brown versus Board of Education, and then the way that opinion has transformed things throughout the world. Lots of reasons to have these opinions. There has been a massive explosion in what's called cases coming out of the shadow docket or the emergency docket. This is plaintiff coming and saying, whoa, we have an emergency. We don't have time to do all of that. We don't have time to have oral arguments, all the briefing, just decide our case right away. And the Supreme Court has radically expanded the number of cases that it is plucking from across the country that are not fully developed, that don't have records, that not having extensive briefing and oral argument, and just issuing decisions in a fair number of cases saying nothing, including the recent decision saying you can fire all the people and have the people in the Department of Education. Nothing. No. Why is that okay? It seems to me deeply illegal to do that. No, the Supreme Court just said, no, you can do that without any explanation at all. And increasingly, this is what we're getting. And there are many problems with this. I don't even think this is the greatest problem, but one of them is the court is again and again and again and again and again doing this to rule for the Trump administration and to stop the lower court judges who have issues. Like Rick said, think about a theme for the term, and my theme for the term would be the Supreme Court's apparent view that the biggest problem in America legally right now is that lower court judges are interfering with the Trump administration's agenda. And these radical lower court judges, appointed by Republicans and Democrats, who stopping what the Trump administration is saying. This is unconstitutional. This is illegal. The court is repeatedly overturning and overruling those lower court justices and some lower court judges, and sometimes even saying, like disregarding their work, not valuing what they have to say, not valuing the job that they're doing. And we're seeing a lot of a real uptick in threats and violence against district court judges that the court, I think, is fueling. I mean, there have been 24 or more pizzas sent to district court judges in the name of the district court judge's son. There was a district court judge's son who was killed by an angry litigant, and people in MAGA world are sending pizzas to district court judges in his name, in the dead son's name, saying this pizza delivery is for this dead kid's name. I know a federal district court judge who is being terrorized, who they're showing off at his spouse's work. His children have security. It is very scary to be a district court judge right now in this country, and the Supreme Court is absolutely overruling and overriding the work of these district court judges and not supporting them. And even if you exempt out from the kind of personal issue, not taking their work and the record seriously and not explaining to us why it is repeatedly stopping these judges who are having repeated problems with the Trump administration. I think it is a real I think it is a disaster. I think it is a 5-alarm fire. I think we need to pay attention to it. I am very worried about it.
Eugene, Justin was going to respond.
Okay, I wanted to ask something about.
So I had a modest proposal that follows directly on. I share many of Carrie's very same concerns. Part of the problem with the court doing this and not explaining itself is that we don't know why whatever the lower court did was wrong. Maybe it had to do with a procedural glitch. Maybe it had to do with the substance. Maybe it had to do with it's all too sudden. Maybe it had to do with the status quo changed too quickly. Maybe it had to do with somebody had a typo in the papers. We have no idea why. All we know is yes or no. And I think this is controversial, but I think trial courts and appellate courts owe it to the rule of law to act as if those opinions that come down are really just power and not try to guess what the rationale is for them. So, for example, when the Supreme Court says, stop this order that says you may not let the Department of Education fire 50% of its workforce, there's absolutely nothing in the rule of law that suggests that another court couldn't issue an order, in its case, properly before it, saying, okay, Department of Education, you can't fire 50% of the people. And the Supreme Court may say, no. And then another court says, okay, until you tell me why what I'm doing is wrong, I'm going to assume that it was something they did, not something I'm doing, and continue to uphold the legal rules that the court passes down. This is not, I think, advocating for lawlessness. I want district courts, I want appellate courts to obey the rules of law that the Supreme Court gives. But when they're only in individual cases, with individual case numbers saying stop and not explaining why, I don't think that creates any binding rule for any other court in the country. And I would hope that courts act like that.
Yeah, so, Carrie, I wanted to ask you, so, was it more than a year ago now, this would-be assassin shows up outside Justice Kavanaugh's house. Now, fortunately, he, for whatever reason, chickens out. But it sounds like he really, at least, was seriously thinking about murdering Kavanaugh. Now, I think it's just all on him. I think people have sharply criticized the justices for their position on Dobbs. I think they're perfectly entitled to do that. And I do think that in some measure may egg on some people. The more you criticize them as fascists, as oppressors and such, more people might say, we should take matters into our own hands. But I think that I don't blame the critics. But I wonder, Carrie, under your approach, would you blame the critics, right? If you blame the Supreme Court because some people are threatening judges, would you blame the critics of Justice Kavanaugh because somebody actually wasn't just threatening, but apparently showed up kind of planning, more or less, again, even if he changed his mind, to murder him?
There's nothing more that I love than criticism. It's what I do as a constitutional law professor all the time. I love critique. I love criticism. I want more disagreement. I want more conversation. And I believe in passionate disagreement and conversation. So I have no problem with criticizing Justice Sotomayor, criticizing Justice Jackson, criticizing Justice Kavanaugh, disagreeing with all of these judgments. I am concerned about something that I think is different than criticizing the opinions, which is, I think, a lot of the rhetoric that comes out of the MAGA movement is not just, I agree or I disagree with the Supreme Court opinion, and here is why, but ratcheted up to a level of there's evil in the land that needs to be eradicated. And I don't think enough is being done to issue a strong defense of we are all in this together. We can disagree. It's good that we should disagree, and it's good that we have robust disagreement, but we are all in the project of trying to make this country more, or all of these judges are trying to do their best and make this country more just, and we need a robust articulation of those values, and I fear that we're not getting them from the administration. This is not the way the administration talks about judges, and I think it is worrisome. So no, criticism is good, but some of this inflammatory rhetoric I don't think is good.
It is a little mystifying that Chief Justice Roberts, who talks so much about the legitimacy of the court, who has talked in the past about respect for the rule of law, would allow these monumental decisions to come out with no reasoning. And part of it, I think, has got to be the workload. This is summertime. They're usually off. Oh, I'm going to Ireland, and this is one of the few places where justices can make some money. They have a lot of rules about what they're allowed to do, and they're off time. They're allowed to teach, and they teach in some very nice places. And now they're busy trying to crank these things out. And I know it's hard to step away from the cappuccino machine or whatever it is and crank out 3 sentences, but I think it's probably worth it. Before I turn to audience questions, I just want to briefly, since we're getting short on time, talk about what I consider the two most interesting justices right now in the court, Justices Barrett and Jackson. Justice Jackson writing some really impassioned dissents, sometimes solo dissents, kind of unusual for a rookie on the court. Justice Barrett, at one point in the middle of the term, she was like a anti-Trump enemy, and now she's embraced, like people have these different views, but in the case that Carrie talked about, she staked out a pretty far position on discrimination against transgender individuals. So these justices are finding their voice. I'm just wondering if any of you want to reflect on either or both of them and what it tells us about the direction of the court. Or not.
Sure. I guess two things. So I did want to just answer back on the birthright citizenship point, which is I think the reason that people are turning to originalist arguments with the vehemence which they are is because that is what the court will listen to, right? That is the only language in which you can make a constitutional argument before the court. And so I think it's instrumentalist rather than functional, although it may serve a functional purpose. And the reason I think that's true is also because I think there's wild and rampant disagreement on the functional proposition, right, on whether birthright citizenship is good or bad. I actually think it's great. I think it's what's made multiracial democracy go in the United States, and I think without it, we would see problematic reifications of very, very entrenched racial hierarchy. So I like it, and I think it's good, but I think that argument doesn't get you anywhere with this court. I think you actually just have to make the arguments in originalist terms. On the justices, it's interesting watching Justice Jackson kind of forge her own path and be very sort of explicit and vocal about forging her own path. And the funny thing to me is how much it reminds me of Justice Thomas, sort of earlier in his career, so. In the sense Absolutely that he staked out positions that other members of the court were not willing to embrace. He would then cite himself again and again for years, right? Staking out these positions. And over time, some of these positions where he seemed like he was alone on the fringe have moved very much to the center of where the court is, and that's very much to the right of where I am. But I think it's really interesting to see her sort of look at that and learn from that you can, in fact, sort of manifest movement on the court by articulating these positions and by speaking to people, and that there's a persuasive function that these opinions serve. And I just find those parallels really interesting.
I'll add just a tiny bit. The two justices you've mentioned seem on polar opposites, not of the political inclinations of any case, not on the sort of ideological outcomes, but on how much they're willing to consider context beyond the four corners of the case itself. Many of Justice Jackson's, I think, rather impassioned opinions, as Jennifer mentioned, are sort of imploring the public to realize what's at stake beyond the plaintiff and the defendant and the V and the arguments in the middle. In ways that sometimes reflect Justice Sotomayor's inclinations, but sometimes are very, very different. A very realpolitik kind of approach to judging. And Justice Barrett seems to be doing quite the opposite, sort of staying very much within the parameters of the case and calling out a sometimes more conservative majority, sometimes less conservative majority, when they branch out beyond what's involved in the four corners of the case to decide broader issues that she thinks don't belong there because that's not what the case presents. That's also just a very different model of judging. And I think it's interesting to watch these two find their voices in that respect. I think we're the better for having that disagreement fleshed out in reasoned written opinions, which is part of why I want to see more reasoned written opinions.
Yeah, I was going to just say I've watched with curiosity this attempt, which I think is largely on the part of the media, to make Justice Barrett into a really interesting figure of in the middle, and she could go either way, and might not be that conservative. I really do not think that is right at all. I wonder if gender has something to do with that story, or else the media just loves the story that there's a renegade justice who may be unpredictable. I don't think she's that unpredictable. We came up in the academy together. I've been reading her writing for a very long time. I think she is a deeply committed conservative, a lot of embrace of principle. I think she believes in a very originalism, and if you in my areas are LGBT rights and repro rights. No one coming from that perspective would look at her and think she is, a squish, as they, I don't think so. And I think this is a good if you look at the Skrmetti decision that I talked about, she writes a concurring opinion in which she says, no, maybe we didn't need to do it in this case, but I want us to hold that there has been no discrimination against transgender people in this country that would give rise to any constitutional concern. Let me say that again. Transgender people have not faced a history of discrimination in this country that would merit taking a closer look at laws that discriminate against them. And there were people after the oral argument who were saying, oh, Justice Barrett's going to write the majority and she's going to say there's extra heightened concern for transgender people. No. So she has clarified for us, no, guys. I would have gone way further than the majority in that, and to say that these people do not merit concern from the courts under the 14th Amendment, or special concern. So I largely think this is a media creation, that she is some kind of unpredictable justice. There's been one or two cases where she hasn't been to the furthest right, but I just don't think this. Go ahead.
In a couple of Trump democracy cases, she took a different view, in both the case involving disqualification under the 14th Amendment, as well as a hair's difference in the immunity case. And
maybe we'll get so far off the right end that she'll not always go over, but that's where I think the reality lies, not that she is some sort of interesting moderate. But I think that it does a disservice to her. I think she is deeply committed. She's thought about it a long time. She has very strong views. I don't think this portrayal is going to bear out over time.
I think it also shows, although we kind of paint the court as 6-3, and it really is 6-3, conservatives against liberals, Republican appointed justice versus Democratic appointed justice on particular issues, at least from the point of view of a lawyer, if you're writing a brief. Depending on what the brief is, you're not looking for Barrett's vote in a case involving LGBT. You might be looking for Gorsuch's vote, whereas if it's a democracy issue, I've given up on Gorsuch and I'm writing for Barrett. So it really depends on.
Yeah, if we look at the one immigration merits decision, which we don't want to talk about, I promise, but it is 5-4 with Gorsuch aligning with the liberal justices. And so I think that is a configuration that we've seen in a number of cases and makes him interesting in some cases, in some contexts. And I agree that I think that's the way this story needs to be told, not the story of the renegade justice who's fascinatingly, difficult to read.
I just say Gorsuch's federal Indian law jurisprudence is very interesting, and not what you might expect coming from him. So I could make a case that he maybe is more interesting.
So Carrie, I think I entirely agree with, because I think she has identified, well, almost entirely, identified two very fundamental features of human nature, and you always have to figure what the human nature is. One is wishful thinking, and the other is an exaggerated sense of one's ability to manipulate people, especially if one is sort of in the elite media. So I do think there are some people who sort of want Barrett to be a liberal or a moderate, or at least a liberal conservative, something like that. Maybe like Justice O'Connor, who also, for that was somewhat overstated. And I think there are also some people who figure if we only kind of frame her this way, maybe she'll come around to our way of thinking, maybe she'll want our reinforcement. I am pretty sure that Justice Barrett does not want anybody's reinforcement. So I do think that this has been very much exaggerated by some people. I agree with Rick, though, that in fact there are some things that lawyers have to keep in mind, on which Roberts and Barrett and Kavanaugh tend to be closer to the center than Alito, Thomas, and Gorsuch. Sometimes it flips around some, but there is some set of such things. If you look at the way things have voted, that have come down, there are some such. So she's not the same kind of conservative as Alito and Thomas and Gorsuch. Maybe a titch less, but only a titch. It really is a difference between the very conservative and the highly quite conservative, let's say.
All right, we have time for 2 or 3 questions, and I know they're going around with microphones. And let me implore you, please keep it brief and please keep it a question.
Hello, thank you so much for being here. I've learned so much. I'm curious, what is the emergency in the emergency docket?
Oh, it's a magnificent question. So sometimes there is none, and that makes it weird. The emergency docket cases all come up when a party, in the cases we've been talking about, invariably the government, says, I want to skip the normal years-long process that Carrie mentioned. I want to go, the trial court has said something or an appellate court has said something, and rather than wait for that to filter up through the process, Supreme Court, press pause right now. Right now. Part of my concern with this whole procedure, and they have the power to do that, part of my concern with this whole procedure is that decision has been explained to us as a decision that depends a little bit on the eventual merits of the case. How do we think it's going to come out when we finally get there years from now? But also, it's supposed to involve what are the equities involved in the various parties in the case, who's going to get hurt most in the meantime, what does the status quo look like? If we're going to put a brake on this, our strong presumption should be don't put a brake on this. And if we do put a brake on this, we're going to have to consider how putting a brake on this would hurt the various people involved. And part of the critique of the court's use of the emergency docket, of these emergency requests to say, please press pause right now before we work through the rest of the process, is it sure seems from the outcomes and from the occasional sentences we get of explanation, the dribbles, that they're using some other metric now to decide when to press pause and when not to press pause, and they haven't explained what that metric is. It seems to be dependent a lot more on their knee-jerk reaction to the merits of a case, which is something that they've said they're not doing. But it's awfully difficult to reconcile that with what they do seem to be doing, and it's real difficult to fit this into what they've said is the traditional test.
I think the thing that I would add to this is I think one of the things, Eugene had alluded earlier to the kind of historically what this looked like and the fact that opinions were not usually issued when things were in the emergency posture. A lot of those cases were death penalty cases, right, where somebody was about to be executed, really was an emergency, and the Supreme Court was being asked to sort of weigh in on, whether that could proceed or not. And so that is, that's where a lot of the emergency docket action has happened in the past, and what we've seen is sort of an expansion of what it's doing.
So I think if the conservatives on the court were here, I think what they would say is, there are 500,000, some number of district court judges. One of 500 district court judges has issued an emergency order, a temporary restraining order very often, sometimes a preliminary injunction, that blocks a decision of national importance by the one president. And that's not something that we would generally want to see happen. And that is the emergency. Now, you may disagree. You might say it's actually fine. We're actually better off having the errors from these decisions by district judges, if there are errors, because there are always going to be some errors, versus errors by the president. Or you might say, and I appreciate your points, that it may be important to explain it in some more detail. But if you really want to know what they think, I think that's it. I think their view is we as the Supreme Court at some point may need to say no to the president. That's one branch of government saying no to another branch of government. But if you've got an ostensibly emergency temporary decision that actually does interfere with a decision of national importance by the elected president, that's not something that we want to see go into force from one district judge of 500. That's, I think, their position. May be wrong, but I think that's their position.
And I actually think that Eugene articulates what they would say very well. It's just that they've told us they're using a different decision metric than that. They haven't said that. That's different. And that, by the way, prioritizes presidential decisions on items of national importance when they are irreparable. And what the court's supposed to be doing is gauging, so if this thing happens over the next couple months, is there somebody involved who can never get back what is taken away? Maybe that's the president. Maybe that's the person who's rendered to South Sudan. Maybe that's the education department, which can never exist again once it's gone, right? You can't hire those people back. They'll have different jobs. So the standard was, we are told that the standard is seek out the irreparable harm and make sure that plays a role. And I think Eugene's right that the court has now decided that any time there is an interference with something that they deem of presidential national importance, that is the irreparable harm. And that's awfully tough to square with the families of the folks going to South Sudan who will never come back.
For people who are interested in learning more about this, I'll point you to a book by a friend of ours, Steve Vladeck, called The Shadow Docket. It's not called the Supreme Court doesn't call it the Shadow Docket, it doesn't call it the emergency docket. These are just motions that are made to the court, and anyone can make a motion, and motion get denied. They get assigned a different kind of number. But because it's happening so often, now the public's paying attention to it.
And Steve would probably want you to know that Will Bode was actually the person who originated the term shadow docket, which he then used as the title of his book.
He gets a quarter every time somebody
He's been overshadowed. Okay, we'll take another question.
I was wondering if you could tell us what your opinion is on how much the Supreme Court, listens to public opinion. Like, I've gotten things saying, sign a petition, we'll send it to the court. And I'm like, they're not going to listen to us, but I hope I'm wrong. Maybe I should sign those things. I don't know.
Well, this is among one of the most debated questions in constitutional law. So who wants to give a 30-second response? Carrie?
No, that is so unfair. Yes, that is a very deep question. My mind is racing to think of what, how not to spend 10 hours. So I mean, I'd be interested to hear Eugene's take on this, but I'll just talk about, I don't think is an eternal question. I don't think there is an eternal answer. The court is always this measure of, I actually think that's something that's historically contingent and changes over time. So I guess my answer will be about this court. I would say the views of the public at large, negligible to no influence on what the court is thinking. So I think 100% please get involved and read those emails and do whatever you can, but a petition to the court, probably not. There are other ways for you to spend your time. I'm a constitutional law professor, and I'm telling you, that's not the way to do that, even though I believe we the people and we own the Constitution and we are the interpreters and all of this, but they're not listening to that. Which is, I actually don't think it's entirely true that they're monks sealed off. I think there is a much smaller, more elite group of people who they are interested, who they do talk to, whose views matter to them. I think that's about where we are right now. I'm guessing you're not in that group, but if you are, please go to DC, chat away. But it's really interesting. There are so many things to say. I guess I would say it's such a deep and interesting question. And when you think historically, like one of the things is that the same-sex marriage decision came in 2015, and lots of political scientists would tell you that that came right at the time the majority of Americans started to believe that same-sex marriage was a constitutional right. That's not a coincidence. So like there is social movements and social change. The judges grow up in the culture. They get to the court. They are influenced by the thinking of the time. They come to, so in a broad sense, yes, they are people. They are sculpted by all this. In the more immediate sense that that email is getting at, no, I don't think so.
We have time for one final question. Well, it's whoever the people pick out there, I'm sorry.
Yes, you can use the mic once it's brought to you.
I had a question about what you said about birthright citizenship.
Mm-hmm.
Since the Supreme Court already has a precedent, Young Kim Ark, about that the 14th Amendment is already very clear that somebody born and subject to the jurisdiction of the U.S. is a citizen at birth. Doesn't it seem that, you know, whether you agree with the 14th Amendment or not, the way to change that would be a constitutional amendment rather than an executive order?
Well, so I do think the executive order is a particularly weak way to do it from this court's perspective. It's certainly possible the court, when the issue comes up on the merits, might even say, we're not going to reach the merits, just going to say whatever is done here. The president can't do it. Maybe Congress can do it, but not the president. But as to the precedent, you know, the fact is no court has been consistent in its respect for precedent. It wasn't the Roosevelt court of the 1930s. It wasn't the Warren court. It isn't the Roberts court. And especially one precedent rarely really resolves matters unless the justices either agree with the precedent or, on some situations, they say, there's a famous line from Justice Brandeis, it's more important that a thing be settled than be settled right. That this is something not terribly controversial. In a lot of fields, this is the way it is. Not terribly controversial. There's one precedent, but we need to know the rules of the road. That's what we're going to stick with. This is not going to be one of those areas. And the other complication about Wong Kim Ark is that it actually stresses in certain places the fact that the parents of Wong Kim Ark were in fact residents of the U.S. And not just physically present in the U.S. when he was born, but were residents of the U.S. And at the time, it was legal residence because there was no really illegal residence at the time.
Well, they were functionally in an illegalized class of immigrants, right? They were Chinese nationals under Chinese exclusion, and so they were resident, but they were subject to Chinese exclusion provisions.
So I'm always very hesitant to argue with you about this or disagree with you. But my understanding is the Chinese Exclusion Acts would have precluded them from becoming citizens and may have precluded Chinese nationals from coming to the U.S. But at the time they arrived in the U.S., they arrived legally. They were residents of the U.S.
Well, they arrived and there was no...
Right. There were, well...
Right.
Everything is legal unless it's illegal, generally. At least that was sort of the understanding then. So if you look at the precedent is really not as dispositive as some of its defenders say. And there are some preceding precedents that had expressed some doubt about this, that the court in Wong Kim Ark didn't much follow because, again, not everything that the court says is always going to stick. Going forward. So just as the Warren Court was perfectly happy to reverse precedents from just a few decades before, I think very few courts are going to think that one decision with its limitations is going to resolve this. I do think the court will ultimately rule in favor of birthright citizenship because I do think they're going to say, whatever our view of the merits of the policy, whatever our view of evolving constitution, we do think that Wong Kim Ark was actually correct on that point, and on top of that, did not need to limit itself to the requirement of residency. But again, I don't know of a single time when the court has thought, yeah, one precedent from 125 years ago, that settles it, that's the end of the story for us. I just don't think that's the way the justices operate.
I think you need a constitutional amendment to get your preferred policy. Do you?
Oh, yes, that's my point. I think that birthright citizenship is the correct interpretation of the text and the Constitution in the original meaning. And I think the originalists would take that view because they will agree that that's the proper interpretation of text and original meaning. If they were, though, had the same conservative ideology but also believed in living constitution, I think they would probably say, well, we think the Constitution lives in a different way. So in this respect, whether you like originalism or not generally, in this respect, the originalist sentiments of the justices on the court are the friends of the defenders of birthright citizenship.
And on one issue, to the point of the courts doing generally well, even despite sometimes the Supreme Court, the birthright citizenship order came out on January 20th. It was in place for 3 days. It was enjoined on January 23rd, and it has stayed enjoined despite the Supreme Court's intervention ever since. The Supreme Court issued its opinion saying the injunctions can only be responsive to the people who brought the case. That same day, there was a class action filed that said everybody like me who was born in the US gets to be a citizen. And an injunction was issued, I think, July 10th, if I'm not mistaken, which is well within the window where the Supreme Court said this won't take effect for another 30 days. So that injunction has been blocked from the get-go. It has stayed blocked, and I think, to Eugene's point, it's gonna stay blocked. There's a lot of mischief being done in the procedural workings in the meantime.
Well, that gives us a cliffhanger, so everyone will have to come back next summer. But please join me in thanking Carrie Franklin, Eugene Volokh, Jennifer Chacon, and Justin Levin for a great discussion. Thank you all. Good night.
Think what a year can bring.